I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into number 99 on our compilation list. So that means we are only one away from the century mark. And I just want to say thank you guys for allowing us to do these compilations for you in between the trial videos, the regular Sovereign Citizen videos. I just want to say thank you guys for the support. And listen, we're just going to keep on doing them and keep on doing our other videos and just keep this train moving. So we're going to be in 3 different courtrooms today. They're going to be all women judges today that we're going to be featuring. Before I give you the name of those judges, just know there will be no commentary added to this video. There will be chapters added, which a lot of you have been saying that you appreciate the chapters being added, because sometimes you may have seen one of these and you don't want to see it again. And you want to jump to the next one. That's why we have added them. So you're welcome. And thank you as well for letting me know that you appreciate that. Now, the judges' courtrooms that we're going to be in on today. First, we're going to be in the courtroom of Judge Alex Manning out of the state of Georgia. Second, we will be in the courtroom of Magistrate Hilary Braley out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Elizabeth Disanto, also out of the state of Michigan. And these were some classic moments here on the channel. So I know you're going to enjoy them. I know you guys are going to have a lot to say in the comments about them. So listen, let's go ahead and jump into 9-9.
Kapuma.
No, your last name.
I am Kapuma.
Okay. What's your last name? Wimbishi?
Kapuma is my last name.
Okay. So what's the first one then?
Wembeshi.
Okay, there you go. They have it reversed. Thank you. Okay.
Yes.
Yeah, okay.
Oh, they have it reversed? Okay.
So it's Wimbishi Kapuma.
So your name is, like, your last name is Kapuma then?
My last name is Kapuma.
Okay. We'll make sure didn't want to destroy it, too bad with my accent. So I guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
Well,
Because
not necessarily. That's just a typo, but
yeah, but according to this,
we're just kind of getting started here. Okay, so I'm just trying to pronounce your name right. That's basically all that is. Okay. All right. So this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay. So we got 285 days without indictment. He had a Feretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of a law enforcement officer with a felony. Officer, if you could raise your right hand for me. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Okay, Officer Marsh.
Okay, so 1 second. So, sir, what this is a preliminary hearing. Okay, it's just to establish that there's probable cause. So the DA is going to ask some questions, and then you get to ask follow-up questions. Okay. All right. So go ahead, Ms. Fields. And this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Marsh, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department, and my title is rank as an officer.
Okay. And are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Regarding Mr. Kapuma.
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the 4th floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the 4th floor. We go to the right where the clubhouse was, and we found a white male victim named Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, Can you tell us what that means?
Sure. So apparently the defendant said that they had noticed the victim had noticed the defendant acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious
Okay.
during that time.
So he was unconscious.
He was unconscious, but he was not unconscious when we arrived on scene. But
You were gaining consciousness.
yes, ma'am.
Okay, now you said that this happened at what address?
Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You can stand if you need to.
Oh, I can see it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that that Mr. Kapuma rendered this man, Mr. Unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16524, the elements of the crime for aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay, and did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What happened with, excuse me, I'm talking
Okay,
about,
all right.
what happened with that?
So during the incident while we were trying to get the defendant into custody, he was resisting myself and numerous officers. So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him into custody. And during that time, that's why we called EMS to go ahead and have them remove the prongs as well as go ahead and check his vitals because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he clearly needed some medical attention, which is why we go ahead and called EMS as well.
Was EMS called for Mr.?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence or just resistance?
There was no offering of violence. There was just actively resisting when giving verbal commands.
Okay. And he said that Mr. Johnson was concerned about how Mr. Kapuma was acting.
Yes. So
can you describe how he was acting and what you were told?
Yes. So what I was told by the victim is that at some point this was a company event that was going on, and during the course of the event, at some point, the defendant had according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson didn't understand. And according to him and several other people at this event, they had never seen the defendant act in this manner before. Mm-hmm. And so when Mr. Johnson went to put his hand on the defendant's shoulder, that's when the defendant acted out.
Altercation happened?
Mm-hmm. Yes, ma'am.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges? Pertinent to this case?
That's pertinent to this case, no.
Okay. That's all I have for right now. It's your witness, Mr. Kapuma.
All right, Mr. Kapuma.
Okay, thank you, Your Honor. I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, step back. What questions do you have for the officer?
Yes, that's who I'm asking, because I can't see him, so.
Oh, okay.
You can't see him on your...
Okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. it was in a hostile situation because I was at a party.
Okay, so stand by. What is your question?
So
Who, what, where, why, when?
So
how?
in that situation, who was the aggressor in that situation? Because he put his hands
Hold on,
first on me.
Just ask a question.
Mhm.
So, okay, so based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
So is there a written signed statement from the witness about that incident to describe what you're saying so that they sworn like a
Hold on,
sworn,
hold on.
a sworn
Who,
affidavit?
what,
I
where,
said-
why,
I'm
when?
gonna have to object. Compound question. Can we?
All right. So you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay. Next question.
So there's body camera for the entire event from all 5 officers of what happened.
Yes. So my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end of the incident as well. So there is a full body camera footage from start to finish, including a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa. No. If you want to say something, you have to ask him a question. So she asked him questions, so you ask follow-up questions to what she asked.
Okay. So based on the body cam video that you're saying, does it show that I was tased until I passed out or died and then had to be resuscitated?
So the body camera footage from Mr. Jones, I would appear because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay. Next question.
So I understand. So when will I be able to see the body cam? Because I haven't had a chance to look at it, see what exactly happened on that event.
All of that gets turned over at discovery, but allegedly you were there. So what's your next question for him?
According to the law, which I'm new to, did I give consent to be arrested? Because according to the
Judge, counsel, or I don't know if I should call him counsel, but
That's actually,
he's been testifying, and so we object to testify.
so did you give consent to be arrested? Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Next question.
was based on my understanding.
No. Next question. If you want to say something later, you can, but what's your next question for him?
Okay, so in terms of the resisting arrest, is it not my right not to resist if there's no jurisdiction over me?
You said stand up?
No, I told him to stand by. I didn't know if you had an objection.
Yes, I have a judge, I understand you're giving him leeway and I understand the reason for that. However, counsel has been not asking direct questions on cross and he has been testifying numerous times. So we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
Yes.
what's your next question? What's your next question for him?
Because for me, it's mainly about consent and
Okay,
jurisdiction.
hold on.
Mhm.
But that's argument. But what question do you have for him?
I don't have any questions for him.
All right.
Okay.
Anything else with the officer?
I do have some redirect.
Okay, go ahead.
So, officer, I know I was calling this, that was my mistake. I meant to say the correct, but the correct victim's name is Johnson, is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma.
Yes, ma'am.
Okay, and That's all I have.
Thank you, ma'am.
All right. Any follow-up based on those questions that she asked?
Basically, not really.
Okay. Thank you,
Okay.
officer. Stay safe
Thank
out
you.
there.
Thank you very much, Your Honor.
Have
Stay
a
safe
good
as
day.
well.
All right. Go ahead with the argument. Let's hear from the state.
So Judge, I believe that we have met our burdens for our probable cause for the first charge, which is aggravated battery. The defendant did render Mr. Johnson's brain useless by, rendering him unconscious for a period of time where he did, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the willful obstruction, we understand there was no violence or offering of violence against, the officers and Mr. Marsh and other officers at the party. So we suggest that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's a name of a strawman or a corporation. So that does not apply to me. It says the accused is capitalized. That's a corporation, and the strawman, which has no bearing to me. And in this matter, I do not give consent or agree to represent my strawman in this case, because I'm a sovereign being. I'm an internationally protected person. But at the same time, from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this regard. Because according to the Fifth Amendment, one of the things is before I can be arrested or detained, I have to be indicted. I have not been indicted. One, I did not give consent to be arrested or to be tried under this jurisdiction because I operate under common law. That's my jurisdiction, common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the gold fringe on the flag and the eagle at the top, which shows this is the maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge. As it relates to how I interact with other humans, it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And based on my international status, because I am a king where I come from, an internationally protected person. So according to Executive Order 143107, which is human rights, this is a violation of human rights. From my understanding of the law and my rights, my unalienable rights, if I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained. That's according to the Fifth Amendment rights. And the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation, which cited that case as into the legality of the constitutional unconstitutionality of any situation, was overturned by the Supreme Court. So in this situation, yes, I did react to Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Johnson. I reacted to a situation. For every action, there's an opposite and equal reaction. He touched me first. I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself. I've been charged with willful obstruction. According to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, Some people would tase me. The officer will shoot me. But if the same thing happens to me, he touched me first. I reacted off of that. That's self-defense.
Okay, anything else? All right, so I'll find probable cause on the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor. And we'll go ahead and address bond. Let's see, because right now bond. Let's see. Right now, as of June 27th, there is a $30,000 good bond.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for terroristic threats act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right. Go ahead with your bond argument, sir.
First of all, it was just a punch, and I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10 months in jail pretty much for one punch in self-defense, in defense of myself. At the same time, I feel like I have already done the time for this.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because the severity of the injury that took place. Yes, Mr. Johnson, he was rendered unconscious. The punch that, counsel is trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that a $30,000 bond is sufficient.
All right, so it'll be no further contact with Johnson. Stay away from Peachtree Street Northeast. You're going to have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still going to live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right. So just supply a good address to the jail upon release. So 15,000 count 1 and count 2 is reduced to a misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
So to this person on the device just labeled Mac, would you be Stephen Smith?
My Christian appellate name is capital S, lowercase T-E-P-E-H-E-N, capital S, lowercase M-I-T-H.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL. So it looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So Again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Okay, thank you. Just a moment. Okay. So, Mr. Smith, as you have likely heard already, you have three basic options when it comes to this citation, and these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation, so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those three options are you going with?
I want to, may I grant my name to the court and make the court trustee?
Okay.
But the option 3, as your question, I deny responsibility and I have an explanation.
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you understand? Do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, at about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him. And when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL until after the firearm was located. He was detained, his CPL was verified, he was issued the citations and released.
And did you have any evidence or witnesses or any other testimony that you wish to present?
Not at this time.
Okay. Thank you. Then, Mr. Smith, it is your turn.
I want to mention there's no damaged property or victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield. While I believe it was racial profiling, considering the area we were in, it wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone because, like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told them I don't consent to any searches, and they were digging in my pockets. I have a legal license, and I'm not suspected of any crimes. So after he said I pulled myself over, he flashed his lights, and they kind of like grabbed me up, and I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person. So I didn't feel the need to because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation. And I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue, I do want to apologize because I did actually have the equipment violation citation as well. That is for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's
Okay.
3.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint, and you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing like I told the officer that pulled me over before.
So, Deputy Sims, I believe when you testified a moment ago, you said you had noticed the window tint. Did you want to respond to that to me, please?
I guess, what are you asking?
You had stated that you initiated the stop, or at least you started to initiate the stop based on observing window tint. Is that correct?
So yeah, I mean, I was with my partner. So there's also the part of he came off of Holmes Road, if I remember correctly, turned right into the parking lot, and then cut through the parking lot to go back onto Holmes Road. It didn't seem like there was any intention of him trying to stop at the store or anything like that. So he's also cutting through the parking lot.
May I add?
You may.
I did not try to cut through the parking lot, as I mentioned before, and prove to the officer before I was door dashing. And if I would have been on my phone, then he would have tried to get me for that as well. So I safely pulled over to where I could view where I was. And it was his presumption that I was trying to turn around in the parking lot, but my car wasn't parked.
Okay, thank you. Give me just a moment. So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint. At this point, the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter. And that is, again, based on MCL 28.45 425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for a first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
you would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So,
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a traffic stop. That was the problem.
at this point, the court has made its ruling. This hearing is concluded. I believe that concludes the docket.
For the people, please. Ms. Bella? Ms. Bella, can you please place your appearance on the record? Ms. Bella? Okay, counsel, you're, Mr. Perpenwalk, Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Paravine Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
So you're all right. So counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case, is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court.
For the videotape, hearing of bail and charges.
Okay, well, we don't have videotape. You can request a transcript, certainly. Yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was just recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request the transcripts.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Okay, yeah, I request that. Also, I request on the Michigan Court Rule 2.003, I believe it's filed that on the 17th on Friday or something like that. So
okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. All right, and so, okay, that's what this one is, that, okay, so this seems to be, so the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one, okay. So let me make a note on here. So I'm just going to note defendant's motion for Zoom transcript denied as it doesn't, Zoom video denied as it does not exist. Right, because you did that on, you recorded that, right, Ellie?
On the 7th?
Yes.
I believe so, but I don't know. I have something from the 7th, but I can't click it while I'm recording.
Yeah, no, I can, you came in to record on that day.
Mm-hmm.
Okay, so I just wanted to confirm that that was in fact done with Ally, so we have the transcript only for that. Okay, and so then you filed something, let's see, I see something else on January 21st. Oh, this must be the copy of the same.
They'll give you 2 copies of each.
Yes, yeah, okay, that's fine, okay, so there's that. You filed something on January 17th, and you're requesting under 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Winnebago Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
Not
reading,
at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate my constitutional rights.
Okay,
Now, and I believe that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir,
I'm with you.
the allegation is that you assault or resisted, obstructed a police officer causing injury and trespassed.
That's
Now,
just an allegation.
you're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing, other than just one. I got like 15 issues in there.
15 issues.
Yeah,
Okay,
you need to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
Okay.
But none of your police came out to arrest me because that's my constitutional right to do. I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote one of my own. If I followed your white laws, I follow them, and then you stomp on me when I follow your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys took dogs out.
Stop right now. I'm not 100 years old, so do not accuse me of stomping on anything.
Well,
let's be very clear on that.
Yeah, well, okay. Yeah, it don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were not.
I did at the city of Woodhaven, though, and now you condemning me for it because you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also took an oath to uphold every citizen's constitutional right to public protest. But you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right. So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did?
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the US Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which this court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your schools and you're wind out, when I go to schools and you're wind out, you should arrest me, but you're not going to.
I do not, let me just clarify. I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, this, and this. I'm trying to tell you I exercised my constitutional rights and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been through your system before.
So
also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment, please. This court, sir, has to take the allegations and there's a process.
Like I don't know it. I know your process. I've been down your roads before. But
I don't know
I'm
what roads of mine you've been down, sir.
I'm 15.
You've been here, excuse me. You've been here in this court a number of times as other matters have been disqualified.
Yes,
and you have been treated with respect and fairness. And I believe you've even stated that yourself.
That's not all entirely true.
Hold on, sir. I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs. You didn't show up then.
Hold on, sir. I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postponed. The City of Woodhaven wrote violation. No, they wrote violations on me for posted signs in this case. In other cases, because I was protesting in the City of Woodhaven. Okay. But on the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid? I'm not. But I'm 15.
Stop there right now, sir. Stop there right now. I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Okay. Was that about a year ago, sir?
It was last year.
Last year.
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're sleepy or stupid. I made sure that there was a judge here to cover it anyway. So whether I was here or not is irrelevant.
The case got dismissed from the City of Woodhaven. But anyway, I'm 15, the defendant under Michigan Court Rule 2.003 requests a hearing by a district court chief judge in case if judge refuses to dismiss herself from this case. I know I have a constitutional right. If you don't dismiss yourself, I have the right for another judge to look at it. This way it's impartial. It's where another judge can look at it and not just yourself. And apparently you want to hold this case for a reason. And I believe that you in the City of Woodhaven, the state of Michigan is in conspiracy. You know what I mean? You guys can say I'm crazy or not, but that's what I'm seeing. Because if you're fighting so hard to keep this case in your court, then something wrong. Something got to be wrong. You already violated my constitutional right to public protest at the City of Woodhaven because of allegations that I committed assault against the police officer? You guys don't even know me.
Sir, okay, stop right there, please, just one moment. So, I'm not fighting to hold on to this case. I was assigned this case by the State Court Administrative Office. Now, I'm also elected to preside over cases. So, unless there's a valid reason for this court to disqualify itself, I am obligated, whether I want to or not, to sit and preside over the matter. I am the chief judge of this court, and so I don't find that there is a basis at this point for me to disqualify myself. However, you certainly have the right to request the State Court Administrative Office can review that. That is absolutely your right. That's how that gets reviewed.
Well, yeah, I want another judge to look at this, because if you don't want to dismiss yourself from this case, we got a problem right there. Because
There's no problem, sir. I have a responsibility. Sir, I have a responsibility. The matter is transferred over to the 27th District Court because the 33rd District Court disqualified itself. Perhaps they sent it here because the other matters that you've had here, I don't know. I can ask for the case to be sent here. It's random. I have zero, just as though when I disqualify myself from a case, it gets sent somewhere else. I have no control over where it gets sent. I have no control over what gets sent to me, whether it's from 25th District Court, 28th District Court, 24th District Court, 34th District Court, or the like, sir.
Well,
So, just so you're aware.
Well, I have a history of this 27th District Court in cahoots with the city of Woodhaven. I think the judge Ken Bash or something like that. He might be up there somewhere. He's retired now. You guys did me the same thing, same way you did.
You guys, I wasn't here.
Well, that's what I'm trying to say. Your system, you wasn't here. You're not 100 years old.
It's not my system. It's the system of the country. It's the entire system. You keep accusing this court that I'm 100 years old and I've been oppressing things for 100 years. That it's my system.
Well, I'm saying
I didn't arrest you. That is not
it's your system.
my system.
And regardless, this is your system. It's not mine.
It is yours. It's
not. I'm Native Indian African. I'm not even a citizen.
No,
I'm a prisoner in my own country because of you white people. Y'all need to go back home where you guys come from.
Okay, sir. Well, let me just say this. All right. You are accusing this court of being biased and prejudiced.
And racist.
Yep. And racist. However, your comments, sir, would seem to suggest otherwise.
Look, why do you raped us, you robbed us, and you murdered us legally?
Stop
Everything
right there.
that you people have done has been legal.
There. It's not you. I did not do that.
You're the system.
Do not put that on me. But here's what I'm going to do, sir. I'm going to grant your request. And this court's going to disqualify itself, and you can figure out which other court's going to handle this matter after the State Court Administrative sends wherever it's got to send, whatever it has to send. Because at this point, I am not going to stay here, take the abuse from you and your allegations, which are completely false and unbased. This court, myself, did not do anything that you're accusing me of doing at all. I wasn't even around at that point. So we're going off the record. You can step outside in the lobby. Somebody will give you the next stuff you have to do.
And I'll give you a call, Mr. Keller. Thank you very much for helping me.
That's all.
Yes.
There'll be another judge assigned.
So am I free to leave, or do I got to get paperwork or something?
I believe that you're all set, sir.
Well, thank you. You have a good weekend and a good year. Thank you.
Good luck to you, sir.
I don't want to violate none of you guys' laws. Heaven forbid.
Okay, I have to wait to write this file. All right, counsel, so there's that. So it won't be this court anymore.
Okay, Judge. I appreciate the judge granting my withdrawal. I will contact and make sure that counsel is appointed to Mr. Peterson if he wants it. But otherwise, thank you very much, Judge. Have a pleasant day, and I'm sorry it had to be this way.
Oh, you're all set. Thank you. Have a good day.
You too.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.